Welcome to The Keys to Your Legacy with your host, Elijah Keys. In each episode, Elijah will have a conversation with other professionals to discuss how their fields relate to trust and estate planning. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, keyslawgroup.com. Now here's the host of The Keys to Your Legacy, Elijah Keys.
Hey, thanks so much for logging in to take a look at the Keys to Your Legacy podcast. We are really excited today to talk to Jordan Becker, patent attorney. This is a podcast where we talk to people about trust and estates issues. So if you're interested in trust and estates issues, then you are definitely in the right area. Jordan is a patent attorney meaning intellectual property and technical stuff, things that I know very little about. So we're really excited to have Jordan on. Jordan, how are you today?
I'm great, Elijah. Thanks for having me on today.
Very welcome. You're very welcome. Thanks for agreeing. So I think that when we were setting up the podcast, you indicated that there's not a lot of crossover between our fields, right? I'm in financial and personal management. You're in patent things. So help us kind of understand what you do in a day-to-day for your clients. And then we can talk about specifically how that might cross over here, because it actually does quite a bit.
Sure. So what I do is I help companies and entrepreneurs protect their innovations. And I do that by first getting a deep understanding of what their business strategy is, and then customizing an IP strategy that is tailored to that business strategy. And usually, but not always, in the high-tech space where I work, that involves patenting, but sometimes it doesn't. Sometimes, for example, it involves opting for trade secret protection instead of patent protection. But when it does include patent protection, I then apply for a patent with the patent office and fight like hell with them to get a top quality patent issued. And so I do that in the area of high tech. So that's mostly computer software, electronics, mechanical devices, sometimes optics, pretty much across industries. But I do a lot in the area of, for example, medical devices, software, including AI, cybersecurity software, and robotics, for example, areas that I work in a lot.
Okay. So you mentioned two different types of intellectual property. I think your firm does four, if I remember right, but looking at the website and your offerings, but I think you mentioned two. You mentioned trade secret and patent. So help us kind of understand what those two things are.
Sure. Well, so there are basically four main types of intellectual property, which are patent, trade secret, copyright, and trade dress. And trademark as well. So the difference between trade secret and patent is that they are kind of mutually exclusive. So if you want to get a patent on something, you basically end up having to disclose it to the public eventually by putting it in a document. Whereas if you're going to keep something as a trade secret, by definition, it's being kept secret. So you kind of have to decide between those two. And there are pros and cons. And I don't know how much you want to get into the weeds on the pros and cons of those things. But for example, if something is going to be very difficult to detect infringement if you were to patent it, if you had to go through very expensive reverse engineering, you might decide to keep it as a trade secret instead of patenting it, because the patent might not do you any good if you don't know if somebody's infringing it. And there are other factors you would consider as well, but those are kind of examples.
Okay. So you talked about patent and trade secret, which sound like it's a production process or a key piece of knowledge in some element that someone wants to use for themselves and enforce against others, right? Is that a fair summary?
Yes. Yeah, exactly. Yeah. So a patent is essentially, it's a negative right. It's the right to prevent others from making, using, selling, or importing whatever is patented, the patented invention.
Yeah. Okay. So help us differentiate then between a patent and trade secret and a trademark and a copyright, because those are two very different things, right?
Right. So patent and trade secret, I kind of already touched on, right? A trade secret is just, it's a commercially valuable secret that derives its value from the fact that it is kept secret and mutually exclusive with patents. So you could have a product that actually has some features that are subject to trade secret protection and other features that are patented, but you just can't have both patent and trade secret on the same feature. Now, copyright protects original expressions. And it covers a lot of things. It includes writings, it includes audio visual works, it includes computer software, sculpture, architecture, dramatic works. I mean, many different things, as long as they're original works of authorship. The thing is, copyright protection is somewhat narrow in
Okay.
scope. Somebody actually has to see or hear and copy the copyrighted work to infringe it, which is not the case with patent. You can be an innocent infringer of a patent. Trademark, on the other hand, and trade dress deal with identifying the source of goods or services. So could be a name, it could be a logo, it could be a sound or a specific color that is used to identify who is the source of goods or services.
Didn't I think that um Paris Hilton tried to trademark the two words "it's hot," and that didn't work, right? But then I seem to remember that Tiffany has a trademark on the color of their box. Is that right?
I believe that is the case, but I can't say for sure.
I think they do. I think they have a trademark on that color. So I mean, I have trademarks on my businesses things, and I actually reached out to your firm because I need to trademark two more things, right? And so we went back and forth, and so that's really interesting. I find it interesting because it's really about ownership, right? It's about enforcing someone's ownership in some sort of business or creative enterprise, right? I mean, that could be, some kid writes a 10-year-old writes a story, it's copyrighted, but it doesn't really have any value. So there's no reason that they would enforce that, right?
Right. I mean, it is about ownership in that we're talking about areas of intellectual property, and they
Mm,
are just property, except
yeah.
that they're not necessarily physical property. But I mean, it's something that you own. It is an asset, whether we're talking about a patent, a trade secret, copyright, trademark, it's all property. It can be bought and sold, it can be licensed. You can do pretty much most of the same things you could do with physical property.
Right. Now, the reason why I thought of you when we learned about this is because I had many clients who were engineers or scientists, and they had patents, and some of them had royalties coming in. I mean, they might have a copyright on certain music on the master, right? And they had money coming in, and they had enforceable contracts. I had a client who was loaning art to museums around the world. And so the question is there a central registration for all of these things that someone can look to?
There is, although it's not a central registration for all forms of IP. So, for example, the US Patent and Trademark Office has assignment records, which are an assignment is legalese for basically a transfer of ownership.
Right.
So, when a patent is assigned or when the ownership is transferred, the assignee or the one who takes ownership normally records that at the US Patent and Trademark Office for all the public to see.
Uh-huh.
In copyright, you register your copyright with the U.S. Copyright Office. So yes, there is a central registry, and trademarks, of course, are registered at the U.S. Patent and Trademark Office.
Right.
Trade secrets are not registered because, by definition, they're secret.
Well, let's say, so this most often comes up in my practice when the owner or the creator of one of these works, right? Patent, copyright, trademark, something. The owner of one of these works either loses mental ability, so they don't remember anything anymore and they can't operate their own affairs. And let's pretend for a moment that the person who is going to take over all the affairs has the legal right to operate all of their property, whether it's physical, intellectual, whatever. What do they do if they see some royalty right coming in through some sort of annual or quarterly payment? They see this right coming in. They see payment from some company, some patent company or some copyright. How what do they do? What do they look for to know that there's actually this right of enforcement?
I guess the first thing I would do is call the payer and ask
Okay.
them what's going on. And I don't mean to be flippant about it, but I
Sure.
think that there isn't a magic answer that applies in every situation. But that's
Hmm.
probably where I would start. And
Sure.
I would also look through all the paperwork of the individual who is either passed away or no longer competent to handle their affairs, and see if you can find some sort of license agreement or other agreement that at least suggests some kind of rights being transferred. And most people might not be familiar with the language you would see in these agreements and wouldn't know how to interpret it. But at least if you have a piece of paper that looks like a legal document that uses words like royalties or license or patent or trademark or such terms, you can then bring it to a lawyer such as myself and ask them, what's going on with this? Can you explain what this is?
Let's pretend for a moment, and this happens pretty commonly among engineers and scientists from what I can see. Engineers and scientists, they like to control things themselves. They're very smart and very intelligent, but sometimes some people don't look past themselves. So they don't know that they need to allow someone else to manage their affairs. What if there's some person out there whose dad or mom or uncle or aunt or spouse even was an engineer and scientist, and they know that this person had patents? How can they know if they have ownership or not?
It's not easy for the average person to find that out, although you can go to the US Patent and Trademark Office assignment database. You can find it using any popular search engine. You just type USPTO assignment records or US Patent Office assignment records, and it's not a hard search interface to use, maybe slightly harder than using Google, but you can type in to a field that says assignee, the name of the person who's in question, who passed away or whatever, and see if any patents come up. Now, usually when somebody works for a company, they almost always end up assigning or transferring their rights to the company. That's normally part of the agreement when you become an employee with a company, that anything you invent or create is going to belong to the company, but not always. And sometimes when a person is an independent contractor with a company, sometimes it's negotiated differently. So you can't be sure, but that's the first place to start, is by looking at the assignment records of the USPTO or doing a search at the US Copyright Office.
Okay. If someone isn't sure, so I mean, that rings true to me, because I've represented a lot of estates where someone was a scientist or engineer. And I remember I represented the family of a former scientist from Xerox, which was a big developer of material science for many, many years. And there were 15 or 16 patents assigned to this individual. So we had to research each individual one and look up whether there was actually an assignment in each one. And there was. Each one was specifically assigned to Xerox. Although it couldn't be obtained by Xerox, it was assigned to Xerox as part of the employment.
Yeah.
Right.
And you have to be careful too, because when you see a patent, it always lists the inventors on the first page of the patent.
Sure.
And sometimes it lists an assignee as well, which is often the company the inventors worked for. But you can't go by the name of the assignee on the face of the patent, because sometimes patents later get transferred. That name is printed when the patent issues.
Right.
And a patent can get assigned many times later in some cases. So you really have to go by the assignment records.
Yeah, I had a great uncle who was an engineer. He invented the initial infrared detection units that are in all security lights. So when you look up at the security light, that was my great uncle who invented that. And of course, he worked for a company that the patent right was assigned to the company. And now, of course, it's not patented anymore because it's been too long. But it's interesting that you look around and you see, oh, that person invented this or that person invented that. That's kind of cool in my
Yeah, pretty cool.
Yeah. Well, Jordan, tell us about you. I mean, we've known each other for a while. We're in the same networking group. But tell us about you. Tell us about family, about what type of things you like to do.
Oh, okay. Well, so I grew up in Bristol, Connecticut, which I affectionately call the armpit of Connecticut. Sorry, any Bristol folks out there. I love Bristol, but it's a small town. And I went to University of Connecticut for undergraduate, majored in electrical engineering, and immediately moved to Southern California when I graduated and went to work in the aerospace industry. And I was actually a rocket scientist. I get a little embarrassed saying that because it sounds a bit like snotty, but that was actually my title. I was an engineer scientist working on the Delta II launch vehicle, which was the rocket that launched the original GPS satellite constellation, as well as a bunch of other satellites.
Very
And so
cool.
that was
That
kind of
sounds
fun.
fun.
I worked on the electrical systems for that for a few years, and then decided that I wanted to go to law school and went to law school in LA. And when I graduated, I was offered a position in Silicon Valley, where I am now, with a patent firm, a patent law firm, and really was quite naive about it at that time, and figured, okay, well, I'll give it a try. And it turns out that to do patent law, you really need a technical background, either an engineering background or a hard science background. And so I was well suited to that without really realizing that was the case. But I tried it and very quickly realized that was exactly what I wanted to do, because I'm kind of a tech nerd at heart.
Sure.
Um, in terms of family, so I'm the youngest of four siblings. I have four older sisters. We're all scattered about different parts of the country now. So I guess that's kind of it. 30 years now I've been practicing patent law here in Silicon Valley in high tech.
Yeah. So I got offered a patent law job
Oh,
from some friends of mine, and I have a background in communication and debate. And so kind of sales, negotiation kind of stuff, right? And so I told them, I don't have a background in this, although I've worked as a C++ programmer. I have training as that. Although I had no formal education, I had training, and I was a beta tester for gaming systems. And I set up my own IT network, right? I can do all that stuff. But actually how things work together at a theoretical side, I don't know. And they said, maybe this isn't for you. So that
that's
got yanked.
interesting. Yeah,
Yeah.
yeah. Well, you could be a patent litigator without a technical
Okay.
background, although many patent litigators do also have a technical background, but not all of them. But to interact with the inventors, apply for patents, and negotiate with the patent office, you do have to
Yeah.
have that technical background.
Yeah. Well, that's about whether you get the patent is the technical background, but whether you're enforcing the patent, the main skill is not the technical background of the patent. The main skill is using the court tools available to enforce the patent against someone else, right?
Exactly. Yeah. Although the litigator does really need to eventually understand pretty well the technology. And so what they do is they usually will partner with what I do is called patent prosecution, even though it sounds like that means litigation. That's not really what it is. But a litigator who does the court work will partner with a patent prosecutor like myself, who has the technical background and can kind of help bring the litigator up to speed on the technology.
It's actually not, it might seem kind of odd, but your and my job is actually very similar. Where my job is to do a very technical job and work on trusts and estates and actually create a fairly technical, robust plan, either before death or after death, and enforce it. But then with litigation comes, I'm not involved in litigation. I don't do that. But a litigator very oftentimes comes to me and asks me to assist on a very technical level about how the very nature of these things work together. And over time, the litigator will come less and less because they've learned more and more. But newer litigators will come fairly often and say, Elijah, will you please serve? I got a request last week. Elijah, will you please serve as an internal expert witness, which means, will you please give opinions here on this case because we don't understand it. We need your help. And my answer was, no, I don't do litigation stuff. No
Yeah.
thanks.
Yeah, it is. You're right.
I certainly
Very
can.
analogous.
Yeah, it is very analogous. Well, this is going to be a shorter episode, and that's totally okay. But the thing that's very interesting to me about trust and estates is that it deals with all different types of property. It deals with property. Today, I spoke to people about real estate in Japan. And the last week, I talked to someone about protecting assets in Alaska, which is a different set of tools. But in all of those things, we have different courts. And so when people are dealing with courts for patents and trademarks, if they're dealing in the United States, let's not talk internationally, are these all federal or state courts or specialist courts? What happens with that?
It's mostly federal courts. Now, there are state trademark rights. Patent rights are federal rights. Copyright is federal. So you're generally dealing with the federal courts there. And in some cases, you're actually doing sort of a quasi litigation in the US Patent and Trademark Office. These are what are called post grant reviews, where I don't want to get too much into the weeds, but it is a litigation option that is often used to try to speed things up because the federal courts can be quite slow. So often the accused party in a patent infringement litigation will try to litigate it in the patent office.
Oh, through some sort of administrative hearing versus using an actual court.
Exactly. And what they're trying to do is to invalidate the patent in the patent office before the federal court has a chance to actually enforce it.
So what Jordan is talking about here is distinguishing between three different types of courts. So let me summarize them very briefly. And Jordan, you cut in and correct me if I'm wrong. There are federal courts, meaning that courts that run under the United States jurisdiction. They are different in every single state, but they operate under federal rules of procedure and federal issues normally, or people who live in different states. But in this case, Jordan is talking about a federal case, which is a patent or a copyright, and those are generally federal. Then he mentioned an internal issue at the patent office. Each administrative body in state and federal government generally has their own internal review structure. So you can utilize that. I utilize them all the time through administrative hearings, through Medicaid or Medi-Cal in California, or administrative hearings through a state function in California. You can do that instead of going to a court. But then also, he mentioned that there are state courts. So California has its own state courts, superior court judges rather than federal court judges. And they sometimes hear different things. It can get really confusing between which is which and what is what. I never appear in federal court. I only appear in state court. Jordan never appears in state court. He only appears in federal court if he goes. And so it's quite different. So I think the thing to take away from here is that different attorneys specialize in different areas. I know very little about patent law. Jordan probably doesn't know as much as I know about estate planning issues. And so really, if you have a patent issue, you want to go see someone like Jordan. But if you don't know who to go to, and you have an issue, Jordan's if he's your attorney, he's a good person to go to say, hey, Jordan, I have an insurance issue, or I have an estate planning issue, or I have whatever issue. And Jordan probably knows more lawyers than you. So if you as a person are looking for specific assistance, if you're my client, you can always come to me. My network is yours. And I'm sure that Jordan is much the same way.
That is true. And thank you, Elijah, for pointing that out. I'm always happy to try to find the right professional to help someone, even if it's not me.
Yeah, absolutely. Well, this is a shorter episode, but that's totally okay. Jordan, thank you so much for coming on. Thank you for spending your very valuable time with us here today. If someone wants to reach you, if someone's looking for a patent person or someone's looking for information about that, how do they find you?
They can find me on LinkedIn, or they can email me at jbecker@perkinscoie.com. That's jbecker@perkinscoie.com.
I didn't know that's how you pronounce it. Perkins Coie?
Coie.
I always thought it was Coie. I even had a cousin that worked there, and I pronounced it wrong every single time I talked to him. And he never
slide there, Elijah.
I appreciate that. All right. Well, thank you. Thank you so much for joining us today. For everyone who's listened, this is the Keys to Your Legacy podcast, where we talk about trust and estates issues. I'm Elijah Keys, certified estate planning attorney. We're really excited to see you. Go ahead and subscribe to all wherever you'd like to see podcasts, and let us know in the comments whatever you'd like us to talk about. We want to talk about what you're interested in. Thank you so much for watching, and we'll talk to you again soon.
You've been tuning into The Keys to Your Legacy with your host, Elijah Keys. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, keyslawgroup.com. Thank you for your positive reviews, comments, questions, and for sharing this show with others.